You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diament.
Hello and welcome to the Patenting for Inventors podcast. I'm your host, Adam Diament, a registered patent attorney and partner at the law firm of Nolan Hyman in Los Angeles, California. This episode is How Universities Handle Inventorship and IP Rights for Student Inventions. So imagine this. You're a college student, you're up late, maybe fueled by coffee or something stronger, and you come up with a genuinely good idea, an app, a device, some clever system that actually solves a real problem. And at some point, the thought hits you, maybe I should patent this. And the next thought that hits even harder, do I even own this? And this is where things get tricky, because the answer is not the same everywhere. Different universities have different intellectual property policies. There's no one-size-fits-all rule. So I want to be very clear about what I'm doing in this episode. I'm not making blanket statements about all universities. What I'm explaining is how this works at the University of California system, based on guidance published by the University of California Office of the President, which you can look up. That matters because UC is actually a pretty good example of how these policies work when they're written clearly. Under the UC system, the default rule is more student-friendly than people expect. Simply being enrolled as a student, taking classes, or paying tuition does not automatically give the university ownership of your invention. If you invent something entirely on your own, without being employed by the university, without using significant university research resources, and without working under sponsored or grant-funded research, then generally speaking, you own your invention. That surprises a lot of people. Students often assume the university owns everything by default. Under UC policy, that's not how it works. But this is a big but. Ownership can shift quickly depending on the circumstances. One of the biggest triggers is employment. If you are employed by the university, maybe as a research assistant, teaching assistant, or in another paid role, you are usually required to sign a patent acknowledgement. The document typically says that inventions created within the scope of your university work are assigned to the university. At that point, ownership is not about fairness or who has the idea first, it's about the contract you signed. Another major factor is the use of university resources. And this is where students get uncomfortable because the phrase sounds vague. Under UC policy, the focus is on significant research resources. We're not talking about studying in the library or using campus Wi-Fi. We're talking about labs, specialized equipment, dedicated research facilities, or institutional funding that goes beyond what is generally available to students. If your invention comes out of that environment, the university may have a legitimate ownership claim. Sponsored research is another big one. If your work is supported by a research grant, whether from the federal government, a private company, or another outside sponsor, the university often has legal obligations tied to that funding. Those obligations usually require the university to disclose inventions and manage patent rights. In those situations, the university almost always asserts ownership, even if the idea feels personal to you. Now, here's a point that causes a lot of confusion. Inventorship and ownership are not the same thing. Being an inventor just means you contributed to the conception of the invention. You can be the sole inventor and still not own the patent. Ownership depends on assignments, policies, and agreements. Under UC policy, if ownership belongs to the university, you may still be named as an inventor. In fact, you have to be named as an inventor, but the university controls the patent. The control usually runs through the Technology Transfer Office. That is the group responsible for evaluating inventions, deciding whether to file patent applications, and licensing technology to companies. If the university owns the invention, they decide how it's commercialized. Students may receive a share of licensing revenue, depending on campus policy, but that's not the same as owning the patent outright. Things get even more complicated when multiple people are involved. Maybe a professor helped guide the work. Maybe another student contributed. Maybe someone outside the university collaborated. Inventorship has to be sorted out carefully, and ownership can end up split between the university and third parties. The kind of mixed ownership can create real headaches later if it's not addressed early. And timing matters more than people realize. If you publish your work, present at a showcase, post online, or demo your invention before ownership and filing strategy are clear, you can accidentally create public disclosures that harm patent rights. That risk exists whether you or the university owns the invention. So if you're a student at a UC campus and you're working on something that might be patentable, the smartest move is to pause and pause early and ask questions. Read the UC policy. It's actually readable. And if things are unclear, reach out to the campus technology transfer office before money or investors enter the picture. One thing I really want to emphasize is that even within a system like the University of California, where the baseline rules are published centrally, there can still be campus-level procedures and interpretations. The UC Office of the President guidance makes it clear that mere enrollment does not give the university ownership, but the moment you cross into employment, sponsored research, or significant use of research resources, the analysis changes. And that's why you should never rely on what a friend told you, or what worked for someone at a different school, or even what worked for someone at the same school 5 years ago. Another common misconception is that class projects are automatically owned by the university. Under UC policy, that is not true by default. If you are completing a class assignment using generally available resources and you are not being paid and not working under a research grant, the university typically does not claim ownership. That said, some classes are specifically structured around sponsored research, industry partnerships, or faculty-led labs. In those situations, different rules apply, and you may be asked to sign additional agreements at the start of the course. That paperwork matters a lot. Hackathons are another area where students get tripped up. Hackathon rules often say you own what you build, but that might be true as between you and the event organizer, but those rules do not override university IP policy. If the hackathon uses university labs, funding, or staff support, or is tied to a research program, the university may still assert rights. It's not malicious, it's contractual, and contracts tend to win. Graduate students need to be especially careful here. If you are a PhD student or postdoc working in a lab, chances are very high that you are either employed by the university or funded by grants administered through the university. In those cases, the invention usually belongs to the university. Even if the idea started as your own, even if you work nights and weekends, that can feel unfair, but it is consistent with how research institutions operate and with the obligations they have to sponsors. Now let's talk about what happens if the university does own your invention. That does not automatically mean that you're shut out. Many UC campuses allow student inventors to license the technology back from the university, sometimes on relatively founder-friendly terms. In some cases, if the tech transfer office decides the invention does not fit their commercialization goals, they may even assign it back to you. It's not guaranteed, but it's absolutely something you can ask about. And that's an important theme here. Ask early, ask politely, ask before you file anything, ask before you pitch anything or sign anything. The technology transfer office is not the enemy. Their job is to manage risk and comply with policy. If you show up after you have already formed a company and talked to investors, everything gets harder. And another thing students often overlook is collaboration with people outside the university. If you work with a friend who is not affiliated with UC and both of you contribute to the invention, now you have split inventorship. If the university owns your portion and your collaborator owns theirs, the patent ends up jointly owned. That can make licensing and enforcement messy. Investors really dislike messy ownership. This is also where assignment agreements matter. Even if the university does not own your invention, you still need to make sure every inventor assigns their rights properly if you want a clean patent. Patents do not enforce themselves, and unclear ownership is one of the fastest ways to kill a deal. One more thing that deserves attention is disclosure timing. UC policy, like most university policies, require inventors to disclose inventions to the university if the invention falls within the scope of university ownership. That disclosure is internal and confidential, does not count as a public disclosure, but presenting your work at a conference, posting online, or publishing a paper absolutely can count as public disclosure. Once that happens, your patent options may narrow fast. So what is the practical takeaway from all this? If you're a student inventor, your rights depend on facts, not assumptions. Enrollment alone does not give the university ownership under UC policy. Employment, grants, and significant research resources often do. Inventorship is not ownership, and early communication saves a lot of pain later. And if you're not a student, but you work with students, hire interns, or partner with universities, this still matters to you. If someone on your team invents something while subject to a university policy, that policy can follow the invention into your company, whether you like it or not. Due diligence always finds these things eventually. Understanding how university IP works is not about gaming the system. It's about avoiding surprises, and surprises in patent ownership are almost never good ones. And that's it for today's episode. I'm Adam Diament, and if you need help filing a patent application or other intellectual property, give me a call at 424-281-0162. And until next time, I'm Adam Diament, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diament directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.